So mini IRAC. A lot of my videos have talked about how to do a full IRAC or TRAC analysis. The problem is a lot of the time on an exam, especially on a very fast pick up all the points you can kind of torts or criminal exam, that if you stop to do a full IRAC analysis, if you write this out for every claim that you encounter, it may be too much. You really need to move faster than that on paper. So the point is that you don't need to put the full thing down on paper once this becomes a habit. The thing is that you never stop doing a full IRAC analysis in your head. And the reason for this is that, in my view, mostly in the law, there are no hip shots. Meaning everything is still ready, aim, fire. And IRAC is a method. At least stopping to do analysis is a method. This is how that you know that you're a lawyer. It's not just that you're making arguments, but that you go through the discipline of thinking about what the issue is, what the rule is, and then analysis as to each element, thinking about what the argument for and against is and what the likely outcome will be on everything. Following IRAC is how you know what you know. It's not just something is the law or not, but that you feel compelled to go through this, that you know that you have to go through this to get a good answer. That's when you finally know that the habits of the law are with you, like the force. So the easy way that I said to do this is to skip the back and forth if the issue is truly easy, and then for close questions, do the full back and forth. What I want to do is show you how I think practically that looks. So what I'm going to do is lay out an IRAC analysis. I'm going back to the Brazilian pies hypo for torts. And I'm going to show kind of what that looks like, what you're doing mentally, and then what you end up writing down. So just really quickly, the IRAC is, you've got an issue that you need to formulate clearly that combines the relevant facts, the actual issue hooks, and the actual legal question into a coherent issue. The rule is a restatement of the applicable elements or factors that you're going to have to run through. The analysis is how you walk through each element, the for, the against, the pro, the con, and then the conclusion on each of those elements, and the conclusion is what you settle at overall. This is TRAC, where you can just use, it has little tiny arms. Instead of issue, sometimes if you don't want to write a whole sentence, sometimes this is easier. You just set out who the parties are, just mention the fact without even using verbs. Pie haters versus don't look crew, thrown pie equals battery, question mark. Okay, all of that's by way of summary. You can see what I say about this in the previous video. This is what the full analysis of the Brazilian pies hypo would look like. Now, to remind you, the Brazilian pies hypo involved two different videos of people manning a booth in Brazil where you couldn't see anything. There's a big round hole, and there's a sign under it that said, look here or don't look here. There were two different videos. So the one that we're analyzing here is don't look here. And it was one of these kind of America's Funniest Home Video things. They filmed passersby getting curious, sticking their head in the hole and getting a pie slammed in their face. So if you were to do a full IRAC, to me, this is a full IRAC. You have the issue and the rule. The issue being formulated however you want to formulate, the rule being battery is an intentional offensive touching without consent. Then the analysis is the bulk of this. You start with intent. You go to the plaintiff here is pie hater, the guy who got the pie in the face. Their argument is to intent. Then you get to don't look here crew. So this is the hypo-specific to the people who wrote don't look here on their sign. Their argument is to intend in some sort of reasonable conclusion. You then go to the element of whether or not the pie throwing is offensive. The pie haters will say it is. It's a goddamn pie to the face. Don't look crew will say that it's not offensive because everyone wants pie. It's not much of an argument. Then you conclude. Then you go on to the next element. Was this a touching? The pie haters, actually, there's not much, a pie made contact with their face. I'm not sure what kind of argument you could make here that wouldn't subject you to sanctions in court as a lawyer. In this element you basically lose, but you're still going through this exercise. Is there something for DLC to say here? The answer is kind of no. And then the conclusion is, yeah, that was probably touching. Was this without consent? And this is one of maybe the tricky issue. When you have a sign that says don't look here and someone looks there anyway, pie haters would argue, this was all a giant practical joke on people who walked by and kind of testing their curiosity. Just because someone looked despite a sign warning them not to look did not mean that they'd consented specifically to getting a pie thrown in their face. Here, don't look crew is a better argument. At least there was some kind of warning. Don't even come close to here. And yet people who did, according to DLC, kind of got what they were asking for, except they didn't know precisely what they were asking for. And then when you come to some kind of reasonable conclusion on that. Okay. And then you come to an overall conclusion on the battery. So there's this. I don't know why I had these random dashes on the outside. But we'll start with touching. So we've gone through this exercise mentally, at least, and maybe even scribbled this down on paper. But one of the things that we're looking for in IRAC is where can we skip writing stuff? Where are issues so clear that we don't have to go through this back and forth? Touching is one of the first ones. The pie made contact with pie hater's face. If there's no real argument here, then we might as well dispense with this and just jump to the conclusion that the pie in the face was a touching for purposes of the tort of battery. Next, kind of go to offensive. Pie hater argues that a pie in the face is offensive. It's kind of one of the classic insults from a clown. If you watch any cartoon or TV ever, the person who gets a pie thrown in his face, it's meant as an insult to that person. It's not something you do. Let's say, and this is the kind of analysis that you might do on this problem, which I haven't necessarily set out in the answer key. Contrast this with like the kind of ritual dumping of a giant bucket of Gatorade over the head of the coach who wins the Super Bowl. In another context, he didn't consent to it, and it's clearly a touching, but is it offensive, say, compared to the pie? It's meant as a way of honoring the coach, even though it seems like on some Super Bowls you'd get hypothermia and die by being splashed by that thing. But that example kind of puts this in perspective. A pie in the face is an insult and therefore is as offensive as, say, spitting in somebody's face. There's not a lot to say in return. I mean, I've seen answers that said, well, some people would love to be able to eat banana cream. I didn't really quite follow what the best argument was here for the defendant. So this is another issue where it's not like a home run issue like the touching where there's basically no argument on DLC side, but it's pretty close. So you make a judgment and you go, let's get rid of that. And let's just, when I write this out, I'm just going to say the pie in the face is traditionally offensive. There's no context in which it's a good thing. All right. Then we go to intent. There's a little more in the points that I've set out um, in the debrief for this. There's a little bit more argument on both sides here, but this is another one, and you're using a little bit of judgment here, but not sure that there's a ton of argument here. Pie haters' argument is basically like these pies did not throw themselves. Somebody threw those pies at the people in the videos who stuck their faces close to the hole. DLC would argue, again, you can say stuff, whether or not it's stuff that makes common sense to anyone other than someone trying to get out of liability for throwing a bunch of pies as part of a practical joke. You know, does it pass the laugh test to say, I didn't intend to commit the tort, to be insulting, to what's the real argument here? Now, in the debrief, in the answer checklist, like there are some arguments you can try to make, but they're not great ones. For the more creative ones, hurrah, give yourself a point. But on this one, I think we can safely skip that and just say there's intent. Those pies didn't throw themselves. Then we kind of go to without consent, and we're looking at this. This is after sketching this out. Can we skip writing this, or do we have to actually work on this? And consent, in my view, is close enough. It's probably a winner for pie hater, but there's enough of an argument on the other side that you want to flesh it out to get additional points. That, again, the point is you're trying to do a couple of things at the same time in the smallest space possible. You're trying to make as many creative arguments that you can that are colorable, that wouldn't get you laughed out of court. And that's a question that it begs, what does it mean to make a non-laughable argument? But as you kind of develop experience through this practice, or I think it's one of the hardest things to teach. It's something that law professors, even though many of them have not practiced very long, have some sense of as clerks. Many of them were law clerks in federal court, and so they've actually seen briefs and issues that were close and issues that were not close in real life. Most of you have not had the benefit of that. But this, at least in my view, is one of the closer issues here. So I would just keep it. So now let's condense, let's wipe everything out, okay? We've taken away the back and forth on intent, offensive, and touching, and we're gonna keep the back and forth on consent, because there's a real argument in the other direction that why are these people sticking their faces in a hole over a sign that says, don't look here, okay? I think there's some other things to try to flesh out. One is whether or not you end up saying much about the issue or the rule. You might make a judgment that you don't have to say a lot. That in kind of analyzing these issues, you don't have to repeat the rule. That's kind of a judgment call. But let's just do it. So, okay, we'll do the issue and we'll just say, battery is an intentional and offensive touching without consent. That's less than 10 words, then do it. Fine, move on. In a mini IRAC, you might also make the judgment, you don't have to keep the conclusion here, because it's still a conclusion that you came to after deliberating through this. If you want to move it up, you can to either replace the issue and title or to kind of fit in here after the rule. You can move it if you want to. You can move it there to say, that DLC is liable to pH under theory of battery for throwing the pie. Here's the battery, here's the back and forth. So I think in this context that could make sense. One of the things that I've said in the past is generally you don't want the conclusion up front. And I have mixed feelings about that. It depends on your confidence in your answer and how many your IRAC is going to be. If it's a very, very clear issue, just set it up front and get it out of the way. If it's less clear, if there's kind of more ambiguity. I don't think there's a ton of ambiguity on this question. There is, at least as to one element, which is enough to call the question the overall conclusion, but even this, I think, leans reasonably in favor of the plaintiff. But if it's a really close question, then I would keep the conclusion at the end to try to demonstrate to the professor that you're following this, that you're not jumping to conclusions, but that you're letting the analysis dictate where you go with the outcome, and not just setting this up to help you arrive at the outcome that your gut has already told you is correct. Okay. So we have all of this. So for the title, so this is what the generic thing is, and I'm just going to walk through how I would fill this out. Title or the issue is battery by DLC versus pH for the thrown pie. Overall conclusion, DLC is likely liable for battery for throwing a pie at BH. And maybe you can even get rid of that. The rule, you can kind of restate the rule batteries very fast. Intent can be inferred from P, and then this, and I want to be clear, this, I'm kind of stepping aside from talking about mini IRAC to analysis generally. A lot of what you write will refer to facts, but the fact in itself does not speak for itself. You don't just set intent up and then say pi, intent, pi doesn't, pies are thrown. What I've written here is an interpretation. There's an inference, or there's some work that you're doing to connect the fact to the law. Intent's inferred here because of the setup of the booth. The whole setup, if you watch the video, is with the intent of getting to throw pies at people's faces for their amusement. So it's that, I mean, now we're talking about premeditation, which you don't even need. You just need the intent in the moment to have thrown that pie. And this kind of common sense thing that it's not like an accident. It's not like pies were falling on people's faces. The hole was horizontal and someone pushed the pie into somebody's face like that. When we fill in these other blanks, little dispute, pie to face offends, pie touch pH, there's no dispute. And then you kind of go through this back and forth. pH says he didn't consent to the pie to the face. The sign didn't say what would happen. DLCs, and this is the best argument you can make, or use that pH consented, that drawing close meant that you accepted the consequences of ignoring a sign that says don't come close. But there's a little bit of, I don't know, kind of the way one kid will just start windmilling his arms and getting closer to someone and saying, you better get out of the way or you'll get hit. I mean, the hitting is still not a passive thing. So here, the conclusion is a close call, or somewhat close call, maybe not super close, but that pH should prevail because consent needs to be pretty clear. I mean, say, watch out doesn't help you very much. I'm going to throw a pie at you. Don't look here if you don't like pie, is a lot clearer. The warning signs that you get, say at SeaWorld when you're in the front row and going to get splashed by a Shamu, or you're in the active row at Blue Man Group where they're going to splash blue paint over you, they're pretty clear about what's going to happen. And here, maybe they weren't. So it's hard to argue that you consented to that. Now you can you don't have to write these things, you don't have to break them out. All this could be one paragraph or condensed even more. But that's what it looks like. So you always think in a full IRAC, and you keep doing the he said, she said, or the back and forth, whatever you call the argument as to each element in each factor. This slows your roll. People, your instinct, I think some of the law is slowing down, at least acknowledging what your impulse is. Oh, that's a battery, or that wasn't, but slowing that so that you don't just start writing and trying to justify that argument. I'm still seeing that in some of the essay submissions. where people are treating this like a courtroom and only making the argument for one side, or assuming when asked if there's liability here and just kind of setting out one case, as opposed to taking an element and looking at it from both sides, taking the next element, looking at it from both sides, etc. So you always think in full IRAC, or at least this can get to be a faster and faster process, which is why you need practice with this. But the whole point of this is that you're not jumping to conclusions, you're walking through a process. And that's the reason for the IRAC framework, such as it is. Even though even IRAC is not fleshed out very well, I think, by a lot of professors, my attempt to flesh it out here is an attempt to give you a framework for thinking through legal problems. But on real exams, you always write mini IRAC. And you'll note that, like, I gave points for writing out the full IRAC on the Brazilian pies hypo because it was one of the earlier hypos, and I wanted people to get into that frame of mind. But when it comes to something like torts or crim, you, again, as I said at the beginning of this section, you're not always going to have time to write out a full IRAC for each issue, and doing so for elements that are basically undisputed will make your professor think that you're not so right. So you always write mini IRAC. The caveat to this is maybe on an exam, the first or second issue that you encounter, you do this full analysis and then you can speed up. Maybe you do a full IRAC on the first one or two issues that you've spotted, and then you move on and do it faster. Let me pause there and see if there are any questions. So Nina is asking, do we use this same approach for exams that don't have as many issues? I'm thinking contracts versus torts. I think that's a good question. I think torts and crim and perhaps even property lend themselves to this kind of faster analysis for mini IRAC, where the point is to see how many points you can collect very quickly. I think I tend to agree that contracts questions tend not to be like that there's a lot of unpacking that you have to do, and you may be better off doing a fuller IRAC for contracts. You have to use your judgment a bit. I'm going to go through some contracts exam organization, and it's still going to seem pretty high level, but I think some of you will still find it helpful. And I think in the context of that, I think there tend to be, because there are fewer issues, the ones that there are, the professor tries to make ambiguous. So I think even if you try to do the mini IRAC approach, you would be more likely to have to do the full he said, she said as to different elements of contracts. Does that make sense? So I think the shorter answer is you can try to use the same approach, but what in fact will end up happening is probably you'll do a fuller IRAC for like con law, Civ Pro, like on issues like personal jurisdiction and subject matter jurisdiction and contracts. Does that help, Nina? Okay, cool.